right, thank you so much. Now we're going to have the introduction of our speaker by none other than our president, Mr. John Barnes.
Good afternoon. Virginia Union students marched to the streets of downtown Richmond and sat at a counter at lunch counter. While they waited to be served, the students sent message that they would not wait in a line. On that same day, almost 3,000 miles away, our speaker, two strong people who had the courage to face the daily scorns of those who condemned their union. She witnessed the many inequities her loved ones faced. Those childhood experiences sparked a commitment to justice and a spirit of activism within her, and the light has yet to be dimmed. Her light was ever bright during her undergraduate career at William College, where she joined organizations such as the Anti-Apartheid Coalition to fight the divestiture of companies doing business with South Africa. She went on to attain a Juris Doctor's degree from Yale Law School and sought to follow the footsteps of the legendary Julius Chambers, beginning her legal journey for change working. First at Ferguson Stein Law Firm in Charlotte, North Carolina. She represented clients from across the state in voting rights, police misconduct, employment demonstration, and criminal defense matters, among others. Transitioning from private to public sector working, first as the Deputy Assistant Attorney General for Civil Rights, and later as the Director of Lawyers Committee for Civil Rights under the Law's Voting Rights Project. There were no detours on her journey. She kept her eyes on the prize of civil rights, and like those Virginia Union students in 1960, she remained true to the Marathon March for Human Dignity. Her efforts to restore hope and human dignity fueled a second passion, a passion for community organizing and coalition building. That passion propelled her to start a public interest law organization. In 2007, she founded the Southern Coalition for Social Justice. The Southern Coalition for Social Justice represents clients and communities across the South, seeking to actively listen to their experiences, prioritize their needs, and their tireless work for the community's view of justice. The day she was born, Virginia Union students are marching for equality in 2018. The citizens of North Carolina saw a candidate who had a long-standing history of doing the same. On November 6, 2018, North Carolina voters stood behind that candidate and elected Anita Earls to the Supreme Court of North Carolina. I introduce to you all a woman who has seen the inequities within the justice system and has continued to shine her light for justice, leaving a lasting footprint here in North Carolina. Ladies and gentlemen, Justice Anita Earls.
Wow, thank you all so much. Good evening. Thank you, President Barnes, for that amazing introduction. And thank you all for inviting me and being willing to let me give you an update from our North Carolina Supreme Court. And I also would be remiss if I didn't especially thank Nicole Dixon, who's been so wonderful in helping me get this set up. She answered my hundreds of questions and whether I could speak and what I could talk about and all those logistics. But I am just so thrilled to have the chance to be here with you this evening. And I don't say that lightly. Recently, I've been disinvited from certain speaking events for the fear that my mere presence could bring negative consequences. So you are brave and courageous to let me come here. And I want to be clear that this is an educational presentation. I do accept invitations from any group or organization that wants to hear about what's happening in our court system. I've talked to Rotary clubs, League of Women Voters, law school student groups, and so please forgive me if it feels like maybe you wandered into a law school seminar. I can promise you that I won't call on you, and there'll be no exam at the end of the evening. Your theme tonight is fighting forward, and as I thought about that, I thought that I hope to provide a foundation by giving you an update of where things stand in your court system. It also reminded me of two book titles, both of these books by Reverend Dr. Martin Luther King Jr. In 1967, he wrote, "Where do we go from here, chaos or community?" And of course, he was forward-looking, trying to chart the course for where the movement should go. But he also, in 63 and 64, wrote, "Why We Can't Wait." And so I think we want to think about fighting forward with a sense of urgency. So what is the overall picture? I'm going to start in your court system in North Carolina as we are here in November of 2023. Let me start by explaining the change in composition of our court. When I joined the court in 2018, my election was the first time in many years that elections for the Supreme Court of North Carolina were partisan elections. Mike Morgan, who was elected 2 years earlier, ran in a nonpartisan race. In 2016, the Court of Appeals races were partisan. And as it happens, if you look at the numbers, the Supreme Court race in 2016 was a first on the ballot when you get to the judges. Court of Appeals races were below that. And yet a full 500,000 voters in North Carolina skipped over the Supreme Court race, did not register their preference at all in the Supreme Court race, and voted for Court of Appeals seats, which is as a political science, I'm sure a political science person would tell you that is highly unusual. Usually people drop off as you go down the ballot. In that election, the Supreme Court race was nonpartisan, the Court of Appeals races were partisan. So there seems to be at least some indication that in 2016, voters saw that partisan label as meaningful to them and something that they wanted to know. At least 500,000 people didn't vote when they didn't have that partisan label. But anyway, in 2018, the court was 5 Democrats, 2 Republicans, and we were all elected for 8-year terms. In 2019, you may recall, the then Chief Justice Mark Martin resigned, and Governor Cooper appointed Sherry Beasley to be the first African-American woman to serve as Chief Justice of the North Carolina Supreme Court. And understand this in the context of over 200 years of our court. Roughly 100 different people have served as justices. Of those, only 7 are African American, all 7 still alive. So it's been very recent. But when that happened, our court was 6 Democrats and 1 Republican. Over the next 2 election cycles, the court flipped entirely. So in 2020, Chief Justice Beasley lost by 401 votes out of 7.3 million votes cast. And then that made our court, the other seats also up, meant that our court was 4 Democrats, 3 Republicans. And then in 2022, there were 2 Democratic seats up. Both of those went Republican. So in January of 2023, the court flipped to be 5 Republican, 2 Democrat. What that kind of lesson sort of teaches us is how quickly our courts can switch, but it also means they can switch back. One seat is up for election in 2024. That's Allison Riggs, who was appointed by Governor Cooper to fill Mike Morgan's seat. Allison Riggs is up for election in 2024. In 2026, my seat is the only one up for election. Then in 2028, 3 seats are up for election. Chief Justice Newby, Justice Berger, and Justice Berenger. Those 3 seats will be up. If Democrats win all of those upcoming elections, the court would again be 5 Democrats and 2 Republicans. So before the next decade of census taking and redistricting, our court could change back to a 5-2 split. So I've told you who's on the court. What can I tell you about how they rule? These are just some numbers. From January of 2021 through December of 2022, so 2 full years, when the court was 4 Democrats, 3 Republicans, we issued a total of 328 cases. In 222 of those, we were unanimous. So 68% of the time, all 7 justices agreed. But that left the remaining 106 cases. In 48 of those cases, Democrats disagreed with each other. So 15% of the time, Democrats were on opposite sides of the case. In 43 cases, so even fewer, all the Republicans were on one side and all the Democrats were on the other side. So in only 13% of the cases was there a direct partisan split. In 8 cases, in 2.4%, in 8 cases, both Democrats and Republicans disagreed with each other. So everybody was all over the map. And in only 7 cases, 2.13% did Republicans disagree with each other. So a very different pattern of how the votes shook out in that 2-year period. The pattern in 2023 so far, we have issued 40 opinions now with our 5-2 court. We've been unanimous in half, 20. So in the 20 with dissent, Democrats have disagreed with each other 7 times, so 7 out of the 20. In 1 case, both Democrats and Republicans disagreed. In no case have yet the Republican justices disagreed with each other. So that's big picture. What can I tell you? That just is numbers. What can I tell you about the substance of the cases? There's a report, and now I'm just giving you a report that someone else did. The People's Parity Project, a national organization, did a study and wrote a report earlier this year about North Carolina's Supreme Court. And they somewhat link who funds elections to how the cases are turning out, but I'm just going to give you the information about what they looked at. So they were interested in cases where big business is up against an individual. And the report is very detailed. You can go to the appendix. You can look at every case they were talking about. But they were looking at things like when an injured worker sues their employee for workers' compensation. They looked at when Duke Power is trying to collect money for the costs of cleaning up the coal ash that was dumped into North Carolina's rivers. They looked at utilities, so that's a utilities case. So a wide range of types of cases, medical malpractice cases, where, again, a business or a corporation or a large governmental entity is up against an individual. And what they found was that Chief Justice Newby ruled in favor, and this is the same 2-year period of my earlier data. Justice Newby ruled for corporations 89% of the time. Justice Berger ruled for corporations 87% of the time, and Justice Berenger ruled for corporations 75% of the time. Justice Morgan ruled for injured people 54% of the time. Justice Beasley ruled for injured people 56% of the time. Justice Hudson ruled for injured people 66% of the time, and I clock in at 71% of the time ruling for injured people. Note that the 71% is still less than the lowest of the 75% for businesses, so there's some difference there. But the point is, you can do this same kind of analysis on other issues as well. And why it's important is because you, as voters, choose who's going to be on our courts, and you have the right to make an informed choice and to know how your court is ruling. So now let me talk about some of the recent decisions. You're probably familiar with what the court has done with regard to redistricting. So the Harper versus Hall case. In 2022, when the court was still 4-3, the court ruled that an extreme partisan gerrymander, the trial court had looked at all the evidence, heard from the experts, ruled that North Carolina's House, Senate, and congressional districts were all extreme partisan gerrymanders. And the court in 2022 said that violates our state constitutional guarantee of fair elections, equal protection, and some sort of First Amendment freedom of association guarantees as well. That it violates the state constitution and required that the districts be redrawn. In 2023, the new court allowed rehearing, reopened the case, and ruled that there are no state constitutional guarantees against extreme partisan gerrymandering in redistricting. Despite a constitutional right for fair elections, under the new court's new ruling, the General Assembly can create Republican veto-proof supermajorities for Republicans in a state where the voters are evenly divided. So one group of justices said we need fair districts, fair to everyone. Under the standard, under the 2022 court ruling, a Democratic gerrymander would violate the state constitution just as much as a Republican gerrymander would. It was a decision that said, here are some standards we're going to apply, similar to the one person, one vote requirement, right? That districts have to be roughly the same size so that everyone's vote has the same weight. But in 2023, the court said that there's no constitutional check on that. In voter ID, again, a trial court heard the evidence and ruled that based on the evidence before it, the voter ID, the statute implementing the voter ID constitutional amendment was enacted with intentional racial discrimination. The 2022 court said, we've reviewed what the trial court did. There seems to be plenty of evidence to support their conclusions. We applied the Arlington Heights factors that the federal government uses to decide equal protection, to decide whether or not there's been racial discrimination. We applied that same standard under our state constitutional guarantees, and we upheld that finding. In 2023, the new majority reheard the same case and held that we're not going to use the Arlington Heights factors. And let me read from the opinion. The Arlington Heights analytical framework is incompatible with our state constitution and this court's precedents, as it allows challengers to succeed on such claims by proffering evidence that is by its very nature speculative, subjective, and thus insufficient to meet the well-established burden of proof. So the majority said we have a different standard under our state constitution and reversed the finding that the voter ID requirement was intentionally racially discriminatory. I just want to share with you Justice Morgan's dissent in that case. I joined him in dissenting, but he said, and you know he has a way with words, it is apparent from the artfully chosen words of my three distinguished colleagues that the reason he's talking about three distinguished colleagues, before the passage that I'm reading to you, he cites from prior dissents of the Chief Justice, of Justice Berger and Justice Berenger, where they accuse the majority of acting in a hyper-partisan way. And he says, it is apparent from the artfully chosen words of my three distinguished colleagues that they have not been reticent about the notion of introducing partisan politics into this court's opinions when they disagreed with various case outcomes. Indeed, these three justices of the majority have clearly been enamored with this strategic approach, which has been conveniently conceived in order to cast aspersions in certain categories of cases, which this court decided in a manner which differed from their three united orientations. Yet now, joined by two more justices who subscribe to the trio's identical, politically saturated legal philosophies, and who were elected to serve on the court since the dissenting opinions cited above were written, the 5 justices which constitute the majority here have emboldened themselves to infuse partisan politics brazenly into the outcome of the present case. This majority's extraordinarily rare allowance of a petition for rehearing in this case, mere weeks after this newly minted majority was positioned on this court, and mere months after this case was already decided by a previous composition of members of this court, spoke volumes. My consternation with the majority's abrupt departure from this court's institutionalized stature, historically grounded in this forum's own reverence for its case law precedent, its deference to the rule of law, and its severance from partisan politics, is colossal. His consternation is colossal. He goes on and he explains, in his view, why the departure from Arlington Heights is not justified. Arlington Heights being the U.S. Supreme Court decision that established how you prove intentional racial discrimination. So we are now in a world where our state constitution provides a different level, a different type of protection against racial discrimination than the U.S. Constitution because of this new majority. So then it won't surprise you if I talk about the case involving the issue of whether or not people with felony convictions, that case had not been heard before the end of the year. So when it came to us in 2023, there was not a prior decision in the same case that was being overturned. And I will just as I say, Justice Morgan is very, he's very good with his words. I dissented from the decision to rehear the redistricting case and the decision to hear the voter ID case, and pointed out that in 200 years of our court, the court had never reheard a case after the court had changed composition in order to change the outcome of a case, and particularly in a case that involves something so fundamental as how our democracy is going to be structured and who gets to vote, right? So, with felony convictions, the trial court heard the evidence. Again, we have a legal process, which I deeply respect. A trial court heard the evidence and found that the statute that provides for how people get their rights back after they've been convicted, that statute was intentionally racially discriminatory. This court in 2023 overturned that, again saying, no, you have to prove beyond a reasonable doubt because we give the legislature every presumption of regularity. And I question, and I wrote a dissent in the case, I question, our court is supposed to protect individual rights. Our court is supposed to protect against racial discrimination. And yet we are saying that there is a higher standard beyond a reasonable doubt. In most civil cases, it's a preponderance of the evidence. But if you're challenging racial discrimination and saying that the legislature has acted in a way that's intentionally racially discriminatory, our court has said it has to be beyond a reasonable doubt. We're not going to follow the factors that the U.S. Supreme Court has found. And so they overturned the trial court, and people with felony convictions who have either not paid all their fines and fees or have not had their rights restored now cannot vote, whereas they could vote prior to that decision. Let me just talk about a couple of other decisions. So earlier this year, we had a case involving selective prosecution or driving while black. An individual in Wake County in Raleigh brought evidence in his criminal case that the officer who stopped him or who investigated him had stopped 82% of the people he stopped were African American, and that this is in Raleigh where 28% of the population is black, and 81% of the people he charged were black. And the issue in this case was what is the significance of those statistics? And the majority decided that basically there was no way to use those statistics to prove racial discrimination. Okay. It won't surprise you then that in a case called State versus Hobbs on the issue of discrimination in jury selection, The previous court had found that the trial court didn't properly evaluate, so when people are called into the jury box and both sides get to ask them questions, both sides have the opportunity to excuse someone without giving a reason, called peremptory challenges. And those are the challenges that can be subjected to potentially a claim that they're being used in a racially discriminatory manner. And think about it, this is jury service, along with voting, is probably the main way that people get to be civically engaged in our government. It's a really important way of exercising your citizenship. So when someone is excused from a jury because of their race, it not only implicates the right of an individual to have a fair trial in a jury of their peers, it also implicates the right of every individual who's otherwise qualified for jury service to serve on a jury. And indeed, the U.S. Supreme Court, in a case Flowers versus Mississippi, which you may have heard about, there's actually a movie made out of this case. If you look at every other southern state, South Carolina, Georgia, Louisiana, Mississippi, Virginia, they all have multiple rulings from their state Supreme Court upholding Batson challenges, upholding the principle that it is unconstitutional to excuse people on the basis of race. North Carolina's Supreme Court had never found a Batson violation ever in our history. So in 2022, we decided a case called State versus Clegg, where we finally set a majority of the court, there were some dissents, but a majority of the court in 2022 said in that particular case, the prosecutor used his peremptory challenges, those challenges he could exercise without cause, in a racially discriminatory way. In State versus Hobbs, we remanded because the trial court didn't apply the right analysis. And when that case came back in 2023, the justices who had dissented before were now in the majority, and they said there's no problem with the jury selection. And I'll talk about one final case. There's a lot. We've been busy this year. There's one more case I want to talk about. If you care about environmental protection, we had a case involving Blunt's Creek, which is in eastern North Carolina, a mix of salt and fresh water. It's an extraordinary estuary that has bass, bream, catfish, gar, puppy drum, black drum, spot. I could go on and on, like all these different types of fish, right? And fishermen, hunters, outdoors people, flock to this creek. But the North Carolina Department of Environmental Quality issued a permit that would allow Martin Marietta to dump 12 million gallons of wastewater into this fragile ecosystem each day. Our court reviewed that and said that was fine. I wrote a dissent explaining why the science introduced in that case did not suggest that it was fine. So those are the kinds of things. The final thing you should know, and I'm not commenting on this case, I'm just giving you the status of the case. As you know, school funding and the Leandro litigation over how public schools will be funded has been an issue of great concern in this state for many, many years. Our court has just now, in 2022, the court issued an order that the legislature had to, or that the state had to fund the school system in an amount that experts and a court had decided was necessary, but the legislature had refused to appropriate. So our court said the guarantee of a sound basic education has to mean something. The Leandro litigation had been going on for something like 25 years. It was time for the state to fully fund the programs that are necessary to give children across the state in public education the level of education they need to be productive members of our society and for them to fulfill their potential. That's what we said in 2022. Then with the new court in 2023, they allowed a stay, so that money has not been paid. And just recently, they have issued an order allowing to rehear the case, to reopen the case. So if you care about educational funding, if you care about the environment, if you care about ending racial discrimination, if you care about fairness in the criminal justice system, these are all cases that it would be valuable for you to know about. A couple of other things I want to make sure you hear about. There have been some important legislative changes in the budget that impact how our court system operates. Up until now, since we've had a Court of Appeals since in 1967 until 2023, if you lost your case in the Court of Appeals, so if you go to trial, say you have a car accident, you think the court applied the law wrongly, you automatically can appeal to the Court of Appeals. If you lose in the Court of Appeals, if it's 3-zip, if none of the 3 judges on your panel agree with you, then you can petition our court to hear it, but we don't have to. Up until now, if it was 2-1, if at least one of the judges in the Court of Appeals thought you were right and you should have won your appeal, then you had a right of appeal. You didn't have to, but you had the right to appeal to our court. That was ended in the budget. So you no longer have a right of appeal based on a dissent. Our court will decide what we hear, and it takes 3 votes to allow a petition for discretionary review. So when you have a 5-2 court, you're going to be challenged. And on top of that, our court has also adopted the practice of unpublishing Court of Appeals opinions, which means that opinions that the Court of Appeals thinks are precedential, we can wipe out and say they have no precedential effect. And the impact of that is to concentrate control over the jurisprudence in the hands of the majority in the North Carolina Supreme Court. Why does it matter? I want to just for a minute talk about a case that you may have heard about. Has anyone here seen the documentary Silver Dollar Road? I know my husband has. Yes, so this is an incredible documentary. If you have Amazon Prime, or I urge you to watch it. It's the director, Raoul Peck, tells the story of the Earls family in Carteret County. And it's a story of how they have battled for years and years and years to hold on to their property. They own 65 acres. Just a very small slip of it is on the waterfront on Adams Creek. The family history is just remarkable. So Elijah Earls purchased this property in 1911. So you know where Carteret County is just up from Wilmington. 12 years after the Wilmington coup, this man was able to purchase 65 acres of property, which they then used for farming. In 1944, the family almost lost the land briefly when a lien for taxes was executed. But then Mitchell Earls, so one of Elijah Earls' sons, was able to pull together the $400 that he needed, and he bought the property back from the county. So Mitchell Earls owned the property. But in 1971, he died without a will. He had 11 children and a wife. So one of his daughters, one of Mitchell Earls' daughters, went to court 5 years later to establish that these 65 acres of waterfront property, which I think in 1976 still was seen as not that valuable. It was in a part of the county that really it's past New Bern. It takes a long time to get out there, not prime development. But later, of course, some development has been going on around this property. And to long story short, now a development company is claiming to own 13 acres, and the 13 acres that are on the waterfront. They sued 2 of the family members, Melvin Davis and Curtis Earls. They sued them for trespass in 2002. A court ruled that they were trespassers. In 2006, they tried to appeal it. Their attorney had been disbarred. They came to the Center for Civil Rights in 2007 or 2006, and I did represent them briefly. And I lost their case in the Court of Appeals. Lost their case 3-0. There was nobody who thought I should win. And so I asked the North Carolina Supreme Court to hear the case. They refused. Then the family went to federal. I left the Center for Civil Rights. The center kept representing the family, but because I left, I could no longer represent them. They've had different attorneys file suit in federal court trying to enforce their rights, and I'm skipping over a lot of legal detail. But in 2011, Melvin and Lycurtis were continued to be found in contempt, and they were put in jail. They stayed in jail for 8 years. And finally, successive attorneys kept going back to court. You all may know Terry Richardson out of Wilmington. He represented the family for a while. He lost in the Court of Appeals and was fined $11,000 because he brought the case. They fined the attorney for bringing the case. Finally, in 2018, the case was heard again in the Court of Appeals on the sole issue of whether or not it was proper to hold these men in jail. And in the film, you see them, being shackled and led into the courtroom. But the Court of Appeals again upheld that it was okay to hold them in jail, but there was a dissent. And because of that dissent, it came to the North Carolina Supreme Court. Supreme Court heard argument, didn't write an opinion, but remanded to the trial court to say, you need to assess whether or not these gentlemen can actually do what it is you want them to do. They wanted them to tear down a building. Do they have the financial means to do that? You can't put them in jail without a finding that they have the financial means to do that. And so finally they were released in early 2019. Raoul Peck, who did the documentary, it is completely from the family's point of view. And he defends that. As a filmmaker, he defends that. He says, I refuse the usual balance, which is to try to get a false objectivity. That's a common problem with documentaries. They try to reduce it to the concept of a good guy and a bad guy. I'm not interested in the bad guy, because when you do that, there is one individual who is the cause of the problem. It's a structural problem. So I urge you to think about what parts of the legal structure contributed to this circumstance, and think about how the fact that they did have a right of appeal based on a dissent that is no longer available to litigants in North Carolina. The final thing I want to talk about is the Judicial Standards Commission, because the legislature also changed that. So ethics for judges has been in the news a lot lately, and it is a good thing to have a code of judicial conduct. Judges should be ethical, and there should be standards that they are held to. But the challenge is if that commission is not used appropriately. Up until now, North Carolina had a balanced commission in the sense that the governor had some appointments, the General Assembly made some appointments, the Chief Justice made some appointments, the State Bar made some appointments, there were judges, lawyers, public members, it was balanced. The legislature changed that, took off all of the lawyers, and gave the Chief Justice and the legislature 12 of the 14 appointments. And that all has taken effect that was in the budget bill. There were not committee hearings to look at whether this was a good policy decision. There was no input. No one got to come and testify about, yes, this is a good idea, or no, it's not a good idea. Happened in the budget. The change was made effective immediately. And so that is who we now have implementing our Code of Judicial Conduct. And I'm not going to comment on it, but I'll give you the status of the litigation that I'm involved in, because earlier this year, a complaint was filed against me with judicial standards, and the complaint was that I had told people about this change ending the right of appeal based on a dissent, and and I told people about our court unpublishing Court of Appeals opinions, and the allegation was that it was improper for me to do that. So only 6% of all the complaints filed with the Judicial Standards Commission ever get investigated. But this complaint against me was investigated. I had a 2.5-hour investigative interview. I hired an attorney to defend me. We've submitted essentially a legal brief to the commission, and that complaint was dismissed. But a few weeks after it was dismissed, a second complaint was filed against me. And this complaint was about an interview I gave with a legal publication in which I addressed the problem that The people who argue in front of our court are disproportionately white males, very few women of color in particular, and also very few people of color argue. And I talked about implicit racial bias. And so the allegation was that by doing that, I had brought the judiciary into disrepute. So I have, in my view, the First Amendment allows me to say those things and to talk about our judicial system in general because of my commitment to equal justice under law and because of my belief that our judicial system is where we're supposed to get justice. The status of the case is that I've asked for a preliminary injunction in federal court. I had a hearing 2 weeks ago, and I just have to thank Courtney Patterson for coming from Kinston to be with me in Greensboro for that hearing. We're waiting for a ruling. The Judicial Standards Commission is asking me to be interviewed, and I don't know where this will go. But my point is that I think it is valuable for you, the public, to know what is going on in your court system. I think it is valuable for you to have an appreciation of what are the threats to judicial independence in this state. And all of that is because you are the voters. You have the right to vote. And so I know everyone in here votes. I know that you all know how to do civic engagement. And what I really want to do is just give you the inspiration to appreciate and understand how the rest of us are depending on you. Every day that I walk into that courthouse, I think my hope is with the voters. So I'm going to conclude by sharing with you the words of our former President Barack Obama about voting. And he was talking to a graduating class at Howard University, but this is what he said. You have to go through life with more than just passion for change. You need a strategy. I'll repeat that. I want you to have passion, but you have to have a strategy. Not just awareness, but action. Not just hashtags, but votes. You see, change requires more than righteous anger. It requires a program, and it requires organizing. And your plan better include voting, not just some of the time, but all the time. It is absolutely true that 50 years after the Voting Rights Act, there are still too many barriers in this country to vote. There are too many people trying to erect new barriers to voting. So you got to vote all the time, not just when it's cool, not just when it's time to elect a president, not just when you're inspired. It's your duty. When it's time to elect a member of Congress, or a city councilman, or a school board member, or a sheriff, that's how we change our politics. By electing people at every level who are representative of and accountable to us. It's not that complicated. Don't make it complicated. Thank you.
Please remain standing. Justice Earls, we really appreciate what you've shared tonight, all the information, in particular Cividala Road. I mean, I'm glad that you shared that with everyone. Glad you didn't give us an exam, by the way. But no matter where you go in the state of North Carolina, in this nation, we want you to know that there are some people in Wayne County that care about you and care about what you do, and that we support you. Okay? So let's get loud with it, y'all. Thank you so much. We ask that Nicole, will you please come and make a call, please?
Good evening, everyone, and thank you so much for coming. But I actually want Mr. Deshawn to actually bless us with a song before I make that call, if that's okay. Thank you. This song is, I just wanna praise you forever. Come on, let's all sing it. Forever.
never, for all you done for me. Yeah, blessings and glory and honor, they all belong to you. Thank you, Jesus, for that. Y'all sound good. Yeah. I just wanna praise you forever and ever and ever for all you done. And blessings and glory and honor, they all belong to you. Thank you, Jesus, for bless. Let's sing it one time, like real strong. Oh, I just wanna praise you forever and ever and ever for all you done for me. Oh, blessings and glory and honor, they all blessings and glory and honor, they all thank you, Jesus, for blessing me.
All right. As I said, thank you so much, everyone, for coming out tonight. This has definitely warmed my heart. I'm not gonna cry like I did last year. But it has definitely been a very, very crazy year, not to say several months, okay? But it's also been amazing. And I am absolutely grateful to be a part of this family. I'm so grateful to Judge Earls for answering my message. Thank you so much. She's so amazing and such a beautiful lady and very humble. And so with that being said, I can tell you that the NAACP to me is one of those organizations that first off has been here forever, right? It's one of the oldest organizations that we have, okay? One of the oldest activist organizations that we have. Therefore, it is very much a...
The mic is pretty much up on the podium.
Oh.
They're streaming from back there.
Okay.
You have some important information.
I don't want to make sure that, okay, can you hear me? Okay. And so with that being said, like I was saying, that the NAACP is one of the oldest activist organizations that we have. And it truly is still very relevant, okay? It's very important that we continue fighting forward. We have to do what we need to do to come together to make this community the best community that it is. I've been so grateful and honored to be able to be a part of a campaign where I was able to meet a lot of the amazing people in this room, in Goldsboro. The engagement that I had was just absolutely amazing, and to me, it just made me feel even more so proud to be a part of the NAACP. Okay, people may say whatever they want, but until you're actually a part of something that's greater than you, just be quiet about it, okay? So I just want to read this excerpt that I got from the actual organizational page because I think that it's relevant in terms of that call that we're asking tonight. Each and every NAACP member makes a difference to the complex, ongoing work of advancing racial equity. We have driven the hardest fought wins for civil rights and social justice. With you by our side, we can accelerate the next milestone for Black Americans. Join this multi-generational network of activists dismantling structural racism by using your power to take action on the most pressing issues of our time. And just like Judge Earls said earlier, we are still in this fight, okay? So if there's anyone who would like to join tonight, please come to our table and we will gladly accept you. Thanks so much again, and I appreciate all of you for being here.
Thank you, and we promise you will not have to wait in line too long. Okay, want to, before our closing remarks, want to recognize two of our elected officials. Ms. Brandon Matthews, want to sign. You can stand up so we can see that pretty red dress. And Mr. Roger White, newly elected. Glad to have you. So, and to let you know where my heart is, we got some youth anti-violence ambassadors. Will y'all stand up? Youth anti-violence ambassadors. All right. Now the house is in order. Our President John Barnes was coming to give us closing remarks.
Before I make my remarks on Courtney Patterson, who is one of our state vice presidents. You got it.
President Bonds, thank you. You know, I want to just share with you, earlier this year, Brandon Matthews, we got into a little thing there where the city council was trying to change the way that it would elect the Goldsboro council people. And we were able to get lawyers to come in and offer this. Fran, you were with us. And I want you to know that this lady right here is the reason that we were able to get lawyers. She started the Southern Coalition for Social Justice. And the two attorneys that were down here were from that firm. She has fought throughout the state for voting rights. Not only that, but that firm has had caused many people have their crimes or charges expunged so that they could get jobs. And I just want you to know that we have got to stand behind her. We have got to stand behind her. We can no longer walk around and allow people to divide us. We have to stand behind her. We have to, I know everybody in this room votes. I know that everybody in this room votes, but it's not enough. We've got to make sure that everybody we know, and even some of those people we don't know yet, go vote. And this is going to be the thing that hold us together and the thing that make the changes that we need to make. Thank you, President Bonds.
I just want to say to Justice Earl, on behalf of the Goldsboro, Wayne, and OC branch, we thank you for being our speaker for tonight. My remarks can be brief. Voting is the right that people have fought for and died. Today, we're still fighting on every front to keep our voting rights intact. We must remember that every vote counts, and when we stay at home, it won't be counted. Case in point is the local municipal elections that we recently held in Goldsboro, where less than 20% of the registered voters came out to vote. Less than 20%. In the mayor's race, the race was decided by less than 9 votes. 6 votes, recounted, 6 votes. And the other council seat, one council seat was won by less than 12 votes. That's not good, folks. It's not good. When we don't vote and people are elected, policies are put in effect that hurts people of color. So we have, and the NAACP is going to do its part, but we need everyone sitting in here to help us to make sure that people who are registered vote, and those who are not registered get registered. That is the only way that we're going to affect change here in Wayne County. So we got to get out and do it, folks, and we can't wait until the next election or whatever. We need to start doing it now so we be prepared for the next election so that people who are registered are able to get out and vote. And once we get them registered, we got to make sure they get to the polls. Now, we are nonpartisan, but we can get out and get you to the polls and get you registered and give you the facts on candidates who are running. And you make an informed decision as to who you want to vote for. But you got to know something about the candidates that are running in order to make that informed decision. Don't let other people make the decision for you. You have to make it. So our goal is to make sure that we get the information out, but we're going to need people to help. When we have our membership meetings here, it's the same people who's on our executive committee meeting. Maybe 12 people. We got more than that who are on the membership road, about like the church road. You're on the road, but you're home, waiting for us to do something. So we want you to be on the road, but we also want you to be here doing something. So the membership meeting is the fourth Thursday, 6:30 here at, and Rebuilding Workplaces has graciously allowed the branch to come here and meet. Thank God, free of charge, because we're able to do it, and we're here for the community. But we need to. Yeah, this month is Thanksgiving, so we're not meeting. It'll be the following fifth Thursday this month, 6:30. Okay. At this time, we're gonna have our third vice president, Jane Smith, to come and give us our benediction. And again, we thank you to the executive committee. I appreciate all the work that you have done in supporting me my first year. I got one more year.
Mr. President, I think you deserve another year. I couldn't help myself. Again, so very thankful for each and every one of you who have come to share with us over here at Goldsboro, Wayne. Very special thank you to Mr. President, our membership chair, Ms. Dixon. Job well done. Let's give her a hand. Hey, bow our heads, please. Our Father, our God, we come before Thee with our heads bowed and our hearts humble, thanking You for this opportunity to get together one more time. Thanking You for each and every participant who have been a part of this program. Continue to bless Justice Earls as she leads the way. Father God, You know her heart and her heart's desire. Amen. Father God, we pray for her and her family. Thank You so very much for allowing them to be with us this afternoon. We pray that everything that has been said and done will be pleasing in Your sight, because we are fighting forward To God be the glory for the great things he has done. Amen.
Amen.
That's it.